Now, legal problems and complaints and notification to APRA are a big problem because they fail to deal with them in a decent and correct way. Many of these are not made in good faith. They do not fall within the reasonable legal scope of APRA, which doesn't seem to worry APRA all that much. For example, there are commercial disputes, issues outside clinical practice, and as we all know, they are not properly investigated. They're certainly not investigated properly before APRA takes action, which is a big, big problem. Complaints can be lodged by business competitors, vested interests, whistleblowers, and they can be lodged on racial, gender, age, and other non-clinical issues. Professional jealousy is a big driver of complaints that are made to APRA in the guise of being mandatory notifications, and hearsay evidence is accepted by APRA. With regard to hearsay evidence, this is something that should never ever be accepted, and it is something that we need to get APRA to discontinue. There's a lack of clarity in detail, and also past history and past cases and past notifications are not regarded as sacrosanct as far as the person who's on the wrong end of these notifications. Now, in the legal system, you cannot bring up those past performances or slights on your career until there is a verdict, and APRA doesn't follow that sort of requirement. Subjective views are another thing that a problem, and an example of that is that a patient had a major problem with obesity and previously had repeatedly declined to act upon the advice given to him by his practitioner. The practitioner decided that he needed to be more forceful with this gentleman to get the message across. So he just said, look, you are too fat and you need to do something about it. And this generated a complaint to APRA. The practitioner apologised for being abrupt and being concerned about his patient, but was referred to a hearing of the medical board, nevertheless. APRA is just an organisation that is a law unto itself, unfortunately. Now, there's a lack of clarity in the details of complaints that come in. It's insufficient, and for example, Mary had to deal with a practitioner who was required to respond to a verbal notification, nothing in writing, and that the real problem has remained unclear after months of review. There's insufficient insufficient consideration of what has been the genesis of the complaint. With regard to these sort of things, it's very, very difficult. There was a young general practitioner who set up a medical practice in a country town, and the country town had an established medical clinic. he performed so well that the clinic, through the guise of so-called patients, lodged complaints to APRA about him. Now, the substance of the complaints was that, one, he acted outside his scope of practice, and number two was that he was working without proper assistance at his clinic. The genesis of that was that he had longer practice hours than the clinic, and he had built up quite a substantial practice in the town. Now, Mary represented him, and it took a long time to get the complaint put to bed, and it was a huge cost to the young doctor. He had to bear the cost of it. So there you go. That was to the detriment of the junior doctor, and it was also to the detriment of the local population, because obviously he was providing an excellent service to them, but he survived. The other thing is that there are unacceptable delays with regard to the handling of complaints by APRA. They're very quick to demand responses from people who've been notified, but very slow to respond. And that's something that really needs to be addressed. And it causes huge problems for the practitioner, including stress, threat to career, financial difficulties, marital stress, all those sort of things that we're all so familiar with. And as a matter of fact, family breakdown is not uncommon, and there have been instances of suicide which followed, and one could assume were caused by people being pursued by APRA. And there's a case of near suicide where a specialist was saved from that situation at a critical time by his wife, when she diligently searched for him and found him and rescued him. And fortunately he survived, but he didn't survive APRA. He was overseas trained, so-called, also Australian trained, because he had to sit the examinations out here, even though he had brilliant CV, and he was a leading authority in regard to the work he did as an orthopaedic spinal surgeon. He got targeted in Townsville for the usual reasons, that he was just too good. And the locals made the point that they didn't want to hear his audits or anything like that, because they couldn't understand what he was doing. Instead of trying to learn from the man or use his services and skills, they tried to crucify him. And he was of such standing that he was the convener of the Asia Pacific Orthopaedic Spinal Surgeons Association education program. And that's one of the problems. If you're very good at what you do, you're more likely to be challenged than someone who's not. The big problem that I see, and probably the major problem that I see at the moment with APRA, is the way they hastily place conditions on people who have been notified. The thing is, they don't do any investigation or get any response from the notified practitioner before they decide on what's going to happen. And in other words, you're guilty until you're proved innocent. And the problem in APRA is that there's obviously a lack of knowledge of specific areas of health service delivery. Health service delivery is very complex, and people who haven't been involved in it at the workplace have a very poor understanding of what's required. Some decisions, like cautions, cannot be appealed. Cost of an appeal to a tribunal or a court is excessive. Medical indemnity insurers will often not cover the costs of appeals. and the penalties that they hand down are unnecessary conditions in so many instances. I mean, our membership here and a lot of people who haven't yet joined as members have had the problem of conditions being placed on their registration and without any reasonable sort of hearing. And to revert back to the spinal surgeon, he had conditions placed on him here. He was actually forced out of his local hospital, and on the day that he was forced out, he actually had inpatients waiting for their surgery. Plus the fact that he had people on his waiting list to operate on. And yet, when he left Australia and returned to his natural France, or his native France, AHPRA provided the French medical registration authorities with their registration assessment of him. However, the French medical situation was much more apropos of the situation, and he had no trouble getting registered in France, and now has a burgeoning practice in France. And as part of Mary's presentation, I will recount at the end of this what's happened with regard to some of the other issues with him. Mary has got some suggested solutions to what's happening. I've just got to look through my cheat sheet here. Sorry. Yes, now, medical indemnity insurers and legal support is a problem. The insurers will not fund appeals from APRA decisions to tribunals, courts, or in many cases. In fact, they rarely do. Thus, there are insufficient current legal court precedents for the lawyers to have to provide guidance and scrutiny of the current regulatory system. The medical indemnity insurers and their appointed legal representatives must improve their performance to fulfil their obligations to the insured practitioners. There's a lack of vigorous defence of members. Not only a lack in my view, but this is not Mary's view, I suppose, in my view, but there is no attempt in a lot of cases to properly defend people who've been attacked. And the emphasis too often is on ensuring that the accused complies with all the demands that come in from the regulator, rather than mounting a genuine defence for the person who's been impacted. Now, I hark back to the situation of the spinal surgeon just to give you an example of the impact on patients. This is something that's totally ignored by APRA and is not well known in the community. A patient of Richard's from far north Queensland was scheduled not on the day that he was shut out of his private hospital practice, but in the subsequent few weeks to have some very major spinal surgery. He had a condition that was lifelong to his spine, and it had progressed. He had had previous lower back operations, and he needed further correction of problems in his upper spine. It had got to the stage, his problem, of being very incapacitating. His quality of life was deteriorating. And Richard had assessed him, and a supervisor that he had to have, once APRA put conditions on his registration, was going to assist him at the operation, because he thought it was appropriate for this fellow to have surgery. Well, unfortunately, Richard returned to France. He showed the case and discussed it with a panel of more senior spinal surgeons in France, and they all agreed that this man needed the operation. So, unlike another patient of Richard's, a lady who has mortgaged her home to take advantage of the offers that Richard made to these two people, if they can get themselves to France, he will do the operation without charge. And he will be assisted by other senior orthopaedic spinal surgeons in France. Now, the lady has organised for her fares and expenses and that to be covered by mortgaging her house. This man is in no position to do that. His conditions continue to deteriorate, and he applied to the federal government for assistance for travelling overseas for essential surgery. To cut a long story short, that's been refused. Now, it's been refused because there is no orthopaedic spinal surgeon in Australia who will review the case and provide a response, and that's what the federal department needs, and I agree with that. But the thing is that the man who was supervising him, and who's a very, very senior clinician, very experienced, and also is a fellow who, in one of his reports that he sent back to APRA on subsequent, there was a cascade of complaints against this fellow, and one of the complaints he reviewed, and his summing up of it was, I am very, very concerned about the use of APRA complaints for this sort of thing. But that didn't strike a chord at APRA. Anyhow, he refused. He was approached personally. He also refused. And then he got a letter which arrived just the other day from the Health Minister or her representative in Canberra saying that they weren't able to assist him because there was no one in Australia who would review the case and say that the surgery was essential. Now, we have a neurosurgeon in Brisbane who has also been targeted by people up there who does spinal surgery as well, and he does it very well, and he has agreed to review it.